Okay, I have 9 o'clock, Your Honors, if you're ready.
Good morning, everybody. Welcome to the First District Court of Appeals oral argument this morning. We have several cases on our docket, but only one to be argued this morning. And the case to be argued is City of Reading versus the Fraternal Order of Police. Ms. Barbier, Ms. Neff, if you will both please introduce yourself to the court, and then we can get started as soon as the introductions are made.
Good morning, Your Honors. Katie Barbier here for the appellant, City of Reading.
Good morning, Your Honors. Katie Neff on behalf of the Fraternal Order of Police.
Thank you both very much. Ms. Barbier, of your 15 minutes for argument this morning, would you like to reserve any time in rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes in rebuttal.
All right, I will keep the time and I will let you know when you have about a minute or so left. And anytime you're ready, you may begin.
I appreciate it. Good morning, Your Honor. I'm Katie Barbier for the City of Reading. We are here today on an appeal of a motion to vacate an arbitration award. The motion to vacate was filed in the Hamilton County Court of Common Pleas following an arbitration over a grievance involving the termination of Officer Anthony Roth, who was a former police officer with the City of Reading Police Department. Officer Roth was terminated from his employment with the City of Reading after 17 years of subpar performance with the City of Reading, specifically subpar performance on his performance evaluations that Reading conducts on a quarterly and then ultimately annual basis with the City of Reading. Officer Roth was warned prior to his termination. He received warnings in 2013, 2015, and 2017 with respect to the possibility that his performance could lead to termination. He received both oral and written warnings prior to his termination. And
so is it your position that those warnings constitute part of the progressive discipline that's mentioned in section 10.2?
Yes, Your Honor. We believe that the warnings, the 3 warnings he received prior to his termination, constitute part of progressive discipline, although it is ultimately our position in this appeal that progressive discipline was not necessary to follow due to the bargain for discretion, the contractual discretion of the Chief of Police to decline to follow progressive discipline in situations where he feels it's warranted. And also
but that sounds to me like a dispute over what the contract requires in 10.2, and that's squarely within the arbitrator's province given our standard of review. And even if we think the arbitrator is wrong about that, I mean, our hands are kind of tied at that point.
Your Honor, my distinction I made in this appeal is not so much that we're disagreeing over the remedy imposed by the arbitrator, which I agree the arbitrator's remedy is within his discretion, and that's the purpose of an arbitrator. But the situation here was that the arbitrator departed from the terms of the collective bargaining agreement because he imposed requirements in the contract that did not exist, which were, the chief had the discretion to depart from progressive discipline when just cause merited it. And the arbitrator said, well, I'm gonna ignore this part of the agreement and I'm going to impose additional requirements with respect to the chief's ability to impose discipline outside of the progressive discipline matrix by suggesting that it has to be reasonable and justified. And I think he went, in his opinion, he went through a couple other factors that he imposed in addition to what the chief already had bargained for within the contract. So our position is that, I'm sorry.
Ms. Barbier, let me interrupt you there and ask a kind of a follow-up question to that. I mean, in essence, I think what you're saying is he imposed sort of like in a contract where there's an implied good faith and fair dealing element, that your argument is that he implied a term with respect to the use of discretion by the chief of police. But let me give you a hypothetical. Let assume that the conduct was the most minor infraction of just cause you could imagine. Is your position that the chief of police's discretion under the collective bargaining agreement is unlimited, that no matter how small the infraction, the chief has the discretion to jump straight to termination?
Our position is that No, not specific. If there's just cause, which the contract requires for the chief to do any kind of, take any action under the contract, then yes, I believe that the contract says that if there's just cause, and the arbitrator in this case found there was just cause for termination in this case, then the chief has the bargain for discretion under the contract to take an action that he believes is appropriate under those circumstances. So, I mean, in this.
But which provision are you talking about? Because I don't see what you just said in section 10.2.
The provision that the chief has the bargain for discretion.
It says the chief may determine that a different sequence is required in terms of progressive discipline, but I don't read that as you can throw progressive discipline out the window.
I guess that our position is that in this case, with the following of the oral and the written reprimand, the chief was then able to skip the suspension, which is what the arbitrator ultimately ordered here. The chief's ability to skip that and determine that a different, matrix or a different progression is correct or appropriate under the circumstances of the particular instance. And in this case, the 17 years of subpar performance evaluations by Officer Roth. So the chief in this case determined, as he testified at the arbitration hearing, and as the arbitrator noted in his opinion, that that Officer Roth had proven to be something of an incorrigible employee. He refused to correct his behavior after years and years and years of response to his subpar performances. He had, as I said, oral and written warnings, and he constantly disputed the feedback he received from the higher ups within the department. He refused to correct or conduct himself in a manner that the city of Reading felt would meet their expectations with respect to requirements of employment. And ultimately, I think there is law cited in the briefs to your honors that an incorrigible employee is not necessarily subject to progressive discipline. If you can show over the pattern of years and years, the employee will not benefit from progressive discipline. And I think that the purpose of progressive discipline, they have said, is to give an employee or an officer an opportunity to correct and improve behavior that the department finds troubling. In this case, that has proven time and time again over the years to not be an effective course with respect to Officer Roth.
And I certainly agree with your assessment of the facts here and the policies behind progressive discipline, but I still am going back to like what's in section 10.2 and the arbitrator's insistence on following the requirements in 10.2. I mean, that does trace its roots, correctly or not, to the contract. And we're trying to see whether the award draws its essence from the contract.
I guess I would suggest that his failure to acknowledge the chief's bargain for discretion, which is also the term in that section 10.2, it departs from the language of the contract. I mean, he read into it a requirement that he acknowledged in the arbitration agreement or in the arbitration opinion that the chief has that, or the safety service director has that bargain for discretion, but then said, well, if they're going to depart, I'm going to do a whole analysis about why they were able to depart or whether they were not able to depart. And I don't believe that language is in the agreement. And so I guess I would say that to read, both the progressive discipline and the chief's bargain for discretion and both contained within that section of the contract, they both have to have applicability here. And I think that the arbitrator ignored that second provision within section 10.2.
Isn't part of his reasoning was that the officer didn't have a heads up that he was going to be terminated? I mean, that's the whole point of progressive discipline, is to allow the officer to make improvements. And by skipping that step, and there wasn't enough of a heads up in this case. The facts of this case for this officer, which they said was a violation of the agreement.
The arbitrator does say that. I would say that with respect to that part of the analysis, the arbitrator did talk about how performing your job satisfactorily is always a condition of employment, is always a quid pro quo for being paid for what you're doing. So I think the arbitrator did find in his opinion that the Officer Roth was on notice, at least, that if he didn't perform his job satisfactorily, he could potentially become terminated under the, the terms of the agreement. And he also, I believe the arbitrator found that Officer Roth was clearly aware that some discipline was going to result from his continued failing performance evaluation. So whether, it was termination or was suspension or what, but the arbitrator, by finding that Officer Roth was clearly aware some discipline was going to result, I mean, I believe that satisfies and is enough under the, contract to allow the chief to then apply his, bargain for discretion.
Ms. Barbier, did you say you wanted to reserve 3 or 5 minutes?
I said 5 minutes, I
That's-
believe. Yeah,
That's what I thought. You are at your time.
thank you.
Thank you. Ms. Knapp?
Yes, sorry. Katie Neff on behalf of the FOP. The city of Reading's argument here today is essentially that because the arbitrator determined that the city had just cause to discipline Officer Roth, the arbitrator could not review the appropriateness of the type of discipline imposed. And that's just not the law in Ohio. In Miami Township Board of Trustees versus the FOP, which is a Ohio Supreme Court case cited in both briefs, that the Ohio Supreme Court rejected the same argument that the city is now making, determining that where an arbitrator's decision draws its essence from the collective bargaining agreement, and in the absence of language in the agreement that would restrict such a review by the arbitrator, after determining that there was just cause to discipline an employee, has the authority to review the appropriateness of the type of discipline. That decision was...
Don't they seem to have a point that it does look like the arbitrator basically read out the last sentence of 10.2? Seem to deprive the chief of the latitude to figure out exactly the sequence of discipline. And it's not like this guy wasn't warned. I mean, there was like chronic warnings in the record. So I don't know. I have some sympathy to that argument.
I think, Your Honor, I think that what's critical here is what the law in Ohio and the case law ferrets out. And in terms of the warnings, the prior warnings, the arbitrator specifically found that he did not, the 2013 warning that the city claims was a part of the progressive discipline was not, in fact, a warning related to his performance review. The arbitrator also specifically found that the first time that Officer Roth was notified that his employment could be terminated was in October of 2017, in the fourth quarter of the final 2017 review time period. And because of that, the arbitrator did look at that provision that talks about the chief's discretion, which is a permissive provision. It specifically says the chief may choose to avoid to skip a step, essentially. However, what the arbitrator did is he looked at the complete paragraph, the complete portion of 10.2 that also includes a possibility for skipping progressive discipline when an individual engages in illegal conduct or gross misconduct. And so what the arbitrator did, which is within his power, because this collective bargaining agreement at issue here did not have a particular provision restricting the arbitrator from actually determining whether the discipline was proper. What he did is he took that entire provision together and said that what the city needed to show was that the chief considered, I think he said, sorry, I'm just looking for the exact language, that the city did not have a reasonable or non-arbitrary basis for failing to follow progressive.
Well, I think one of the unusual things, or at least strikes me as unusual about 10.2, is the use twice of the word normally. That almost sounds like you should do it, but you don't have to do it. And I think, and I'm wasn't a labor lawyer, but it seems to me that it's usually much more clear, thou shalt impose progressive discipline. And so what are we supposed to make of the word normally that's in there twice?
Right. I think that kind of goes back to the discretion of the arbitrator to interpret the language of the collective bargaining agreement. And in that sense, there are some cases in which the collective bargaining agreement does have the quote shall language in terms of progressive discipline. In this case, normally is used, but it also says that it essentially says that in situations right after it talks about that normally progressive discipline will be used, it specifically says it normally will be used with respect to conduct which could not be a violation of law or classified as gross misconduct, implying that it will be used unless those situations occur. And I do think that, as mentioned by this court in questioning the city of Reading, that while this court may not have come to the same conclusion when evaluating the facts, at the end of the day, the arbitrator has broad discretion. And unless he is specifically instructed within the collective bargaining agreement not to evaluate whether the discipline was reasonable, he is permitted under the law and under the contract to do that. And in this collective bargaining agreement, there is not such a restriction. In fact, in terms of the cases cited by the city of Reading, none of the cases that they cite to are directly on point with this particular case that results in something in their favor. In fact, the case that is most directly on point with what they're citing to is the city of Cincinnati versus Queen City Lodge, number 69, which was the First District Court of Appeals case in 2005, in which the city of Cincinnati had terminated a police officer after an individual died in his custody for multiple reasons. And the arbitrator, the city in that case, argued that there was a managerial right provision within their collective bargaining agreement that said the managers had the right, city management had the right to, make hire, fire decisions essentially. And what this court determined was that provision did not specifically restrict the arbitrator from determining, even though the arbitrator found just cause for discipline, it didn't restrict the arbitrator from actually looking at the reasonableness of the decision or the discipline that was imposed.
Did the arbitrator find that the chief's decision to skip a step was arbitrary?
The arbitrator found that the chief's decision to skip the step was not reasonable, and that it, I was trying to look for the exact language that he used. He determined that the city did not have a reasonable or non-arbitrary basis for failing to follow. I don't know if he specifically said it was arbitrary, but what he did say is that given the fact that the discipline was issued in late 2017, and that was his first warning, in which he was told that if you do not get a passing score in that quarter or for the full year, your employment may be terminated.
So it had to do more with like a heads up that you're getting, because the way I read the arbitrator's decision is that he agreed, first of all, y'all agree that he agreed that this officer should be disciplined for his conduct. And not only that, he even stated that this type of conduct certainly could lead to termination, right? I mean, the arbitrator agreed that this conduct could lead to termination.
Eventually, yes.
position.
Mhm.
So his big problem was really that the officer wasn't given enough warning.
Correct.
Okay. But it wasn't that the chief's decision was arbitrary, right? I mean, this is not an arbitrary decision of the chief. I mean, he had reasoning for it. It's not like on a whim, he just decided the guy looked at him funny and he was going to fire him, right?
I think yes, I think what was arbitrary or questionable was the timing in terms of the timing of the discipline coming, the discipline was for our Mr. Roth's 2016 performance review, which had been issued almost a year prior. And the discipline wasn't issued until the fourth quarter of 2017. And it was also counted as part of Officer Roth's 2017 performance, which resulted in a lowering of his score for the fourth quarter. And then what Reading did is they counted that fourth quarter score in issuing the termination decision, basically saying that because your performance did not rise above a level of 70 for the fourth quarter, we're terminating your employment. So, I think the arbitrator did question in terms of the, the reasonableness from the standpoint of the fact that the discipline wasn't issued until the very end of 2017 for something that happened the year prior. And then that it was also counted again in order to reduce Officer Roth's score even further to support the termination decision. Yes.
Ms. Neff, let me ask you this. The collective bargaining agreement is a contract, and under Ohio law, implied in every contract is an obligation of good faith and fair dealing. The arbitrator didn't use that language, but is it your position that that's in essence what he was doing in light of what you just explained? That the arbitrator was saying, hey, listen, there's discretion, but in exercising that discretion, it has to be, you have to use with good faith and in fair dealing.
Potentially, the arbitrator pointed to the language within 10.2 that talked about the gross misconduct and illegal. He didn't necessarily say that was the only basis for skipping a step, but he did, I think, use that language in informing his opinion that it was unreasonable or potentially arbitrary for them failing to follow progressive discipline. I mean, it's hard to say absolutely that that's kind of what was in the arbitrator's mind, but I think what he tried to do was look at the language of 10.2 and use that to inform, what type of discretion the chief should have as part of the contract, which is, according to the contract, he has the discretion to interpret the contract because that's part of the grievance process.
And is it your position, I'm trying to understand, that the chief doesn't have discretion to skip a step and to not go with the progressive discipline unless the conduct is either illegal or gross misconduct? Is that his only time that he, under the CBA, that he has the discretion to skip a step?
That's not, I wouldn't say that that's our position, but I do think that it is a fair reading by the arbitrator that those things, should have been considered or should be required before he skips the step. And there's a reasonable nexus between that first part of 10.2 and the last part of 10.2. And as our position is essentially that the law in Ohio allows an arbitrator to determine the reasonableness of the discipline, unless the contract specifically prohibits the arbitrator from doing so. And this contract doesn't do that.
You have 1 minute left.
Thank you, Your Honor. So in this case, the city cannot point to any case law in Ohio that supports their position that the arbitrator was prohibited from using his judgment in determining the reasonableness of the discipline imposed. As such, we ask that this court uphold the arbitrator's decision and the lower court's decision.
Thank you, Ms. Neff. Ms. Barbier, you have 5 minutes.
Thank you, Your Honor. I guess the distinction we're drawing here in this appeal, the city is not that we're questioning the arbitrator has the ability to review the reasonableness of the discipline imposed. Our position is that the arbitrator read in additional requirements to the contract that before the chief was allowed to use discretion. So it's not so much the reasonableness of the discipline imposed, but it's more that the arbitrator imposed requirements on the chief to justify his use of discretion in this case, when we think that the language of section 10.2 does not require the chief to do that. And it's not, it's.
Well, but this kind of gets back to Judge Meyer's question about good faith and fair dealing. I mean, if there is discretion, what's wrong with saying, why are you exercising the discretion in this manner?
I don't think that that's what the arbitrator was doing in this case. I mean, the arbitrator was saying, okay, for the chief to justify his use of discretion here, we're going to have to, make this analysis and analyze all of these, these factors. And so I guess our position is, yeah, I mean, the chief, I would say, acted in good faith and fair dealing, just based on the conduct of Officer Roth over the course of his career. And I think as one of your honors pointed out, I mean, the arbitrator actually found in his decision that termination, if in the absence of a progressive discipline policy, termination was probably warranted under the circumstances of the Officer Roth's conduct. So then taking the next step by reining in the chief's discretion under that, be based on the progressive discipline matrix, I don't think is in conformance with the terms of the section 10.2. And I would disagree with counsel's argument with respect to it has to be kind of read in conjunction with, it will normally be followed the progressive discipline will normally be followed absent, gross misconduct or illegal conduct. I mean, there's the next sentence is the progression normally includes a verbal reprimand, written reprimand before a suspension, and a suspension before dismissal. And then the next sentence, totally separate from those, is the chief of police or the safety service director may determine that a different sequence is required. So I don't believe it has to be read in conjunction with the gross misconduct and illegal clause within that section of the contract.
Because the point of progressive discipline is to allow the person to improve their performance.
Right.
Right. And in this case, we've got, I think you said 17 years of subpar performance. So year after year after year, performance is never improved.
Correct. And not only is performance not improved, but the feedback from the officer to his superiors when getting, performance evaluations has indicated a pattern of not being willing to improve performance. And I think that on this last instance, when the chief in October of 17 did say to the, Officer Roth, you either improve your performance or you may be terminated. I think that following quarter, Officer Roth's performance evaluations were the worst they had been. So it is indicated over, history of her career in law enforcement that he's been unwilling to correct behavior. And I think there is law cited in our brief with respect to, progressive discipline is not applicable when the employee has shown, an inability to improve or benefit from progressive discipline. And the chief's discretion in Article 10.2 is to allow, the chief to control his police department. I mean, in this climate, especially given the current climate, I mean, a chief has to make sure that its department is running well, is running safely for the benefit of both its officers and the public at large. And if you're unable to terminate an employee following 17 years of poor conduct, I mean, it's really a liability on behalf of the city of Reading, but also, I mean, to the people that come in contact with Officer Roth while he is on duty with the department. So for those reasons,
you have 1 minute left.
Okay, thank you, Your Honor. I guess I would say to summarize, for those reasons, we respectfully ask this court to vacate the arbitrator's decision and find for the city of Reading in this case, uphold the grievance, or uphold the termination. Thank you very much.
Thank you. That will conclude arguments this morning for the First District Court of Appeals. Thank you both very much. We will take the matter under submission and give you a timely written opinion.
Thank you, Your Honor.
Thank you.
Good day.